My first question is, what is a patent and what's the difference between the other IPs like trademarks, trade secrets, and copyrights?
Yeah, no, it's a great place to start, Richard. Thanks for asking. And it's a great topic because so many people are creating new products that they don't know quite where to start. I mean, a lot of people call me because they're like, I created something, but what do I do next, right? How do I get it to market? How do I make a prototype? How do I get a patent? And I, of course, do the patent side of it. Um, and other people will do prototypes and things like that. So there's a whole kind of army of people you need to bring a new idea into existence. On the patent side, patents really protect a physical invention typically, and when we say physical, that word is used loosely because it might be like software and things like that, but it's some type of new useful invention that has certain structure or function, right? And so you're protecting the thing that you've invented that people are going to make and use. Now, to contrast that, trademarks really protect things that are used as branding tools, right? So we think of names and logos and slogans. Those are branding tools, and trademarks are specific to branding, nothing else. Now, copyrights are a third type of IP, and those are used to protect what we call works of authorship. So if you do some new creative thing, a painting, lyrics for a song, a script for a play, a book, whatever creative work of art that you come up with, you can protect that with copyright. So we're really protecting somebody's ability to create something and have some rights to protect it from other people stealing it and actually copying it. And there's some crossover in all these things because copyrights, these works of authorship, if I create a new design, I might take that design and protect it with a copyright, but then I might also use that design as part of my branding. That's what we do with logos all the time. And so the underlying design itself could be protected by copyright, and the trademarks could then protect that use of that design as a branding source, we call it, or a mark, right? Something that identifies the source of the brand. So you got patents that protect inventions, new and useful structures and functions. You got trademarks that protect brands. You got copyrights that protect the works of authorship. And then you also have something called trade secrets. Trade secrets are those things that you don't disclose to other people. You really need to have a formal program to identify and protect your secrets. And those could be, you could have something you invented, and instead of getting a patent and putting it out in the public, you could keep it a secret, and it could be a trade secret. And but that could also be, we hear about the kind of folklore idea of the Coca-Cola recipe or Kentucky Fried Chicken, spice mix or whatever. If those are actually protected and used for economic benefit, then they can be considered trade secrets. And then all of this stuff comes together it's not actually a type of IP, but you then use contracts around these different types of IP to show that who owns it, to transfer the ownership, to license it to other people. And so I like to think of the four types of IP: patents, trademarks, copyrights, and trade secrets, plus the use of contracts to manage that IP.
If I'm creating a perfume, would that fall into trade secrets?
It could, a perfume. So you could do a lot. I mean, if we just took perfume, right? If I had a client that came to me and said, "Hey, I've got a new perfume and I want to protect it," we'd really want to dig in and identify what it is that they're creating. Did they create a new fragrance, a new recipe of sorts of what they put together and mixed to get that specific fragrance? Are they creating a new type of, because that could be a trade secret if it's more of a recipe type of thing. It's probably not a patentable subject matter, only because an examiner would say, well, a recipe, like this is just mixing known things that already exist, and people have been mixing things to create fragrances forever. So mixing it in slightly different proportions isn't considered new enough to get a patent. It might be new, your fragrance might be new and nobody else has done it, but it's not new enough to get a patent because other people do that. But it's an interesting example because I could think of a company. In fact, there's a company here in Utah where I'm located. They're called Pura, and they do a lot of fragrances. I don't know if you're familiar with them, but they create these little wall plug-in units, and they have these little fragrance packs that you plug into that unit, and then that wall unit has circuitry in it and communications capabilities. You can control it with your phone. You can specify how much fragrance you want to come out. And so they've done like just your one example, you could have trade secrets on the fragrance, the actual liquid perfume that you use, right? You could have patents on the containers that you use to hold that fragrance. You could have patents on the wall device with the electronics inside it to control how much fragrance is released on a certain schedule. And then you put a brand around it, like the brand Pura, and that branding element and it is considered, trademarks. Also, another area of crossover, you could take that wall device and it's got a really distinctive circular, kind of beveled edge look to it. And you could say, well, there's probably also something here that we can protect with design patents. Design patents aren't really the same type as a utility patent. And just to pause real quick, there's three types: utility, design, and plant. And most people don't need to talk about plants, but utility is something that's useful that people make and use. And design doesn't protect the structure and the function of that device. It protects what's called the ornamental look. And when you start saying, well, the look of the device and the trade dress, or the way that look is used for branding, you now start to have kind of overlap between the trademark side of things and the patent side of things. And so you have all this stuff, and so you can really cover, you can cover trademarks in there, you can cover patents, both utility and design patents, and in that you can cover trade secrets. And then I actually work with a company that did a lot of the manufacturing logistics for the actual company we're talking about right now. And that was all, governed by the contracts between the logistics company with the brand itself, and then the contracts with all of the different manufacturing entities and facilities that were making the products, shipping the products around. So I don't know if you I think you were asking a simpler question, but I love that when you start to really look at taking an idea and putting it into a business format, you can see that IP is really a part of it. It kind of shows up in a lot of different places, even just with one, a company with a single product.
So what about if there's an existing product, but you add something on top of it? Could you patent that?
Yeah, you could. So in patents, there are like five or six rules, six requirements that you have to meet to get a patent here in the U.S. And let me just say, every country around the world has their own patent system. They're pretty similar, but they're not identical. And so you have to really be thinking, where am I looking to get a patent? We'll talk about the U.S. We could be talking about Canada, and there are ways to link patents from different countries together through different treaties and agreements that have happened. But here in the U.S., where I'm located, there are like six requirements to get a patent. Two of them are really the most important questions, and they're called novelty and non-obviousness, right? Novelty just means, is my device the exact same as something else that's already out there, or something that's been described in public? Is there, and all the stuff that's out there and that's been described in public, we call that prior art, or the prior technology, right? So if it's identical to something else that's already out there, then won't be considered novel, and I can't get a patent. In your example, though, you've assumed, let's add something so that it's new now. Now the question isn't novelty, because we already know we added something that wasn't there before, so it's going to be novel. It'll meet that requirement. But we have to ask the second question about non-obviousness, and it's stated backwards, I guess, because we're attorneys and we like to make things sound more complicated than they need to be, right? But the real question is, would adding that additional structure, that additional piece or function into the existing product, would it make it different enough that you've created a new thing that somebody else hasn't already thought of, right? Would the change have been obvious change to somebody else who's doing this. Like if we said, "Hey, I've got my shoes, and I want to put a new type of material on the sole of the shoe to make it more have better traction," for example. Right? The question would be, well, would it be really surprising for a shoe company to come out with something that creates better traction on their shoes? Probably not, right? Like that is the purpose of shoes, is to give you traction while you're walking. Now, if they create a new chemical that never existed before, then that chemical itself would be novel and non-obvious because it's a brand new chemical. And if you take that chemical and apply it to shoes, then applying a known chemical that or a known substance, adhesive or whatever, to shoes to give it better traction, you're just saying, I've got shoes and I need traction, and I've got this material that provides better traction. It's already known to do that. It's used on tires, for example. Let's say you use it on tires, and we're just going to take it and we'll put it on shoes. Well, it's the same function. It's just a different application. That's probably considered obvious and wouldn't be patentable. But if I've created an entirely new substance that never existed before, then the substance is novel and non-obvious, and applying that to the shoes would also be novel and non-obvious because that substance never existed. Nobody could have said, well, if I look at everything out there in the world today, this exists and this exists, and put them together, that's obvious. But if this never existed, so then using that in a new, in a way with existing products would also be patentable. I don't know if I've described that well, but the real question is, there's two questions. Is it novel or identical to something else that's already out there? And is it non-obvious? Non-obvious, I think the best way to kind of summarize non-obvious is when you put two things together, did you do it in a way that surprises people? Did you do something, maybe you put two things together that nobody, like people have said, don't put those together, they'll explode, right? Or if you put this with this, it'll make it so it doesn't work. And all of a sudden, when you put it together, it does work. Like that would be surprising, right? Or if you take two things that just are totally unrelated, I don't know. I've got my computer mouse on my desk here, and I've got a light in front of me that's, for my podcasting. I have no idea why I would ever want to put a computer mouse and a light together, right? But if I found some reason to do it, then that combination would probably be non-obvious because they're just like nobody out there would be thinking, let's make a light with a mouse on it or whatever. So combining two things that are an unexpected combination are more likely to be non-obvious and therefore patentable than combining two things where they more naturally go together.
What is a patent troll?
A patent troll? Uh, so patent troll is a term that people have used for somebody who buys other people's patents just for the purpose of suing companies and making money off of lawsuits. So there's a whole history to it. And there are companies, especially in the US, where litigation is pretty easy to initiate. There will be people who will go out, they'll buy other people's patents, especially in like the software space. And a lot of these patent trolls or people, we also call them non-practicing entities or NPEs. And so we say, well, they're buying somebody's patent. They're not buying it so they can make it. They're buying, and if you had a patent and I said, hey, Richard, I want to buy your patent and I want to go make, this product that you invented. I've got the skill set. I know the manufacturers. I'm going to make the product. I'm going to go sell it. I would then be a practicing entity because I've bought it for the purpose of making it and selling it. A lot of these non-practicing entities have no intention of making the product, no intention of selling it. They just buy it up. There was a case around like copiers and fax machines, right? And there's some software that was invented to help run these machines better. And so somebody, for whatever reason that the inventor didn't, decided to sell that off and wasn't making, the actual invention that they created. And so they sell it off to a large, really well-funded group of people. And these people usually layer their companies together, so they're really hard to track who they are. and then they take this portfolio of patents and they go out to everybody they can think of and they say, well, you have a copier, you have a fax machine, we're suing all of you, and they'll sue everybody and they'll ask for a small enough amount that it's not really worth fighting because the legal costs would be too high. But it's enough that it makes it worthwhile to go out and sue people. And so they ask for $10,000 or $20,000 or 100, $5,000. They ask for whatever amount they can get from as many people as they can get it from. And they simply use the patent for suing people to, I don't want to use the word extort, but to compel them to pay money to avoid being sued for patent infringement. And they do this enough and they make enough money that it funds entire businesses.
What is a provisional and full patent?
Yeah, no, great question. This might be for your audience. This might be the most important question because this is where most small businesses start if they're going to get a patent, right? And I talked about utility, design, and plant patents. A provisional patent is a type of utility patent application. And so in a utility patent application, that's the one where we're patenting structures and functions, right? You're a new thing that is made and works. A provisional patent application is a process in the United States and a few other countries. Most countries don't have this, but you file a provisional patent application as a placeholder. And so you're not filing your full application or what we call the non-provisional patent application. You're filing a less formal version of it. You don't have to have all of your formal drawings. You don't have to have claims. You don't even have to have like a full well-written specification. You still need to describe your invention in enough detail that somebody else understands how to make and use it. But you can be really informal about what you file with the U.S. Patent and Trademark Office. File it with a simple document we call a cover sheet that says, this is my invention. These are the inventors. And you pay the fee, $150 or so. Depending on what level of discounts you might qualify for, and you file this as a provisional patent application. The U.S. Patent and Trademark Office simply looks at that filing package. They don't read it in detail at all. They just look and say, did you file a cover sheet? Did you pay the fee? And did you give us a document that you say describes an invention? If you did those three things, then they'll give you an application number and your invention will be patent pending, meaning you can tell the world, hey, I've got a patent pending invention. Now that provisional patent application is only good for 12 months though. It's not meant to turn into a full patent application or even a full patent, a granted and issued patent. It's meant to be a placeholder for the first 12 months. And most people will file that because, well, frankly, it's a lot less expensive to prepare that. It might be, a fourth of the cost to prepare and file that, and it gets them in the door. And then they will use the next 12 months to go out and say, can I actually make this invention? Can I actually sell this invention? Can I sell it at a price that is financially worthwhile to do all these things? And so they'll use those 12 months to explore the validity of the business around their invention before committing to do the full patent application or the non-provisional patent application. So it's really a placeholder.
Besides physical inventions and creating softwares, I'm going to get back to the softwares. Are there any other types of patents that we could do?
Yeah. So that gets into the design patents and the plant patents. Now, I was in a room full of 300 patent attorneys one time, and I asked them, I said, who here has ever done anything with a plant patent? And I don't remember if a single person raised their hand because they're just not very common. Plant patents are for what we call asexually reproduced plants. So if you're in the agricultural research business, you might be working on how to create plants that you can, like new species of plants from existing plants. Most people don't do that. I've worked with one client in the past in 25 years that that had plant patents. So plant patents exist. Most people are never going to come across those. Utility patents we've already talked about for the structural and functional things, and then design patents, like I mentioned before, are really for the. It's not for the structure or function of a device. It's for the ornamental look of a device. And what I mean by that is, think of the two really common examples are cars and shoes. So now you could have cars and shoes that also have utility patents, maybe thousands of them covering the different pieces of the cars or covering pieces of shoes and how they're made and the materials they use. But they also a lot of times will have design patents. So if you think of your favorite shoe brand and you think of some of the design elements that are always on those shoes, the Nike swoosh or the Adidas stripes or whatever it might be, like those are likely cover. Now they'll also be trademarks, but they're likely covered by design patents in some form. And then you might see a specific line of shoes or a line of cars. Like for cars, you might have headlights that have a really specific, unique shape to them. Those headlights might be covered by design patents. The grills on cars that have different honeycomb kind of design. What do you call those? I don't know. The grill. I'm talking about the front of the car, and then in the grill of the car they're starting to use these different patterns. Like those patterns might be design elements, or the actual. I haven't looked into this, but someone once told me that Audi, has a very. If you look at I don't know, the last 10 years of Audis, they've got a very specific outer kind of shape to the grille on the front of their cars. And all the cars share this design element. And so I'm told, they've gotten a design patent on that shape of a grill. So if you wanted to go out and, sell aftermarket grills to be used in Audi cars, normally you could do that and you could do that for any brand. But if you do it with this specific shape, then if they do have a design patent, they would have the right to tell you, sorry, you can't make that shape anymore because that's our design. Like that's part of what we considered, our IP for our cars. So same with shoes. If you have shoes and they've got specific, even if it's not the logo on the side of the shoe, it might be different patterns, the way the leather is cut or the way the materials are sewn and overlapped. And those different elements could be design patent subject matter.
Now, one thing that is crucial, like it costs money to patent. So if you're just getting started in business, is it worth doing the patent because of the costs? And what's your whole take on that? Because it can be 50-50, like someone can steal it or someone may never know about it. So what's your thoughts on that?
Yeah. I don't want to be biased here because I I get paid to write patents for people. And so I do think there's a place for patents in a lot of businesses. That being said, you're absolutely right. There's a cost to it. Not only the initial cost to prepare and file the application, but there's a cost if you filed, a design patent application or a non-provisional utility patent application, or, the same thing applies to trademarks, for example. These things get examined. So there's the initial cost to prepare and file it. And then there's a cost as you go through the examination. There'll be back and forth between you and the patent office or your patent attorney or trademark attorney and the patent and trademark office. And that every time there's a back and forth, there's costs involved with that. So it could easily in the United States for a non-provisional utility patent, it could easily be $20,000 or $25,000 or more to go through the filing and examination stage just to get the patent. And there are companies who spend a lot more than that. They might spend $100,000 on patents. So, and that's just in the US. Remember, I mentioned before that some people, like you can link patents together in other countries. Some people will go and they'll say, well, I want a US patent and I'm manufacturing in China, so I want a China patent and I'm going to sell it in the US and I'm going to sell it in Europe and Canada. And maybe I'm going to have some distribution through Mexico. So I might want patents in the US, Canada, Mexico, some European countries, and China. And now you're saying, well, multiply those costs. Let's just say it's $20,000 per country. Like that becomes, $100,000 really easily for one patent. And one product, I've seen products, simple products. I've got I don't know if the percussion massagers, kind of the massage guns that a lot of people have these days, and you get them and you massage your muscles with them. It just kind of pound your muscles out. There's a company here locally that has that's developed that, and I looked at their portfolio. It was probably a year ago, and they had like 60 patents. So you start to say, okay, one product. That was their whole company. They probably had 20 or 30 on one product. So 20 or 30 patents on one product, probably some patents in other countries on those things. This is extremely expensive, right? So when you're getting started, I totally understand why people say, hey, this is too expensive. It's not worth doing it. That being said, that's why the provisional patent application process exists, is to file something initially and really vet out whether or not this is a viable product, both technically and from a market perspective, before doing it. I have heard other people, and I know instances where people say, I took a product to market and I had a patent, but I just got knocked off and it cost me $20 million to sue people. Like I couldn't do that, right? That's where people have to weigh out their own situation. I also know people who've said, I'm not getting a patent, it's too expensive. They go out and make something, they're selling it on Amazon, and immediately they got 30 competitors all selling the same product. And they could have patented it and they didn't. In fact, I've helped some people using patents or trademarks, get knockoff products off of Amazon because because you have the IP around it. So there's not a really great answer to say, is it worth it or not worth it? It certainly, if you don't have the money, it's really hard to spend the money on getting patent protection. But if you're creating a new product, a lot of times, if depending on what the product is and where you're going to sell it, like to make a new product and get it out to market is a lot more money than the patent would ever cost. And so I think the real thing is, if people creating a new product think, well, I'm just going to put $5,000 into this and sell it, like you're going to make a prototype and sell, or you're going to sew your own thing, or like for $5,000, depending on what it is, you can make some things, but most things you can't make. You can't even get molds for $5,000. Like if you're going to make something that requires mass production, and you got to go to another country to do it, and you got to have minimum order quantities, and shipping, like you're into this thing $100 or $200,000 already, anyways. So the real question that I think is important to ask is, are you going to put $200,000 into designing and making a new product and not protect it? I don't know. I think it's worth a little bit of consideration to protect it, so that you have the option, because that's really what patents do. Well, once you have a patent, you can sue people, you can stop people if you have the money to do that. But everything leading up to getting the patent is all speculative. This is the tough thing with IP. IP, for the most part, is a speculative cost or investment, depending on which way you look at it. For a patentable invention, before you ever put it out there, before you disclose it, before you sell it, before you probably even make it, you're saying, do I want to get a patent on this? And how do we know if it's going to be a winning product or not, right? We have to make small decisions towards whether or not it's going to be a winning product. So that's why a lot of people will do a provisional patent application and then go do some testing, go make some prototypes, go try to sell some to their friends, or or on a larger scale, sell on Amazon, right? And see what happens. And if it works, then you come back and you say, hey, let's make the bigger investment. Let's do the non-provisional patent application. And then there's a point in there where you can say, I don't know if I want to file in other countries or not. So you can file what's called a PCT application. It's the Patent Cooperation Treaty administered by WIPO, or the World IP Organization. And so a lot of people will say, well, I don't know if I want patents in China or Europe yet, but I'm going to pay a little bit of money, a few $1,000s, to file a PCT application. And that will leave the window open for me for another year and a half to make a decision if I'm going to file in other countries. So the real thing is, what is the best way to stage those costs so that you have time to make those decisions? Because you're always making decisions before you know whether or not the product is going to be successful. So I don't know if that's not a straightforward answer to your question, but that's the best way I know how to answer it.
No problem. Where can people learn more about you and Polly?
Oh, I'm on LinkedIn. I love talking about this stuff on LinkedIn and on my website. So I'm at intellectualstrategies.com. That's my law firm based in the US. We have a small legal team that essentially acts as in-house counsel, including patents and trademarks for small startups and scaling companies. So we do this. This is what we talk about all day long, every day.